March 7th, 2021, the Oprah interview. Meghan was asked about royal titles, and this was her exact response. For us, titles were never something we were concerned about. Fast forward to November 2025. A Radar online source described Meghan as panicked and defiant, reportedly consulting legal experts and preparing for a court battle. That same report explained why those titles still carry enormous importance. So much of Meghan and Harry's public influence comes from being the Duke and Duchess of Sussex. Remove those titles, and the entire dynamic changes. Not concerned in 2021. Panicked and defiant in 2025. That's the contradiction everyone talked about. But here's what almost nobody discussed. The title Meghan is reportedly preparing to defend in court, the Duchess of Sussex title, isn't legally hers in her own right. She doesn't possess that title independently, and the person she would reportedly be challenging, William, once he becomes king, would benefit from sovereign immunity against civil proceedings. On top of that, the legal instrument that could remove her HRH status is, according to a published barrister's legal analysis, not open to judicial review. 3 barriers, 0 legal pathways. By the time we reach minute 18, you'll see exactly why, using straightforward documented legal language, and why the commercial operation built around that title is resting on a foundation that no lawsuit can actually reach. So why does a reported legal threat from November 2025 matter today? Because the financial picture has changed dramatically since that report first appeared. Back in November 2025, when Radar Online published the panicked and defiant story, the Sussex commercial operation still had the Netflix agreement in place. As Ever had just launched, the ANL case was still being litigated, and Meghan was reportedly consulting lawyers over a future possibility, what William might do after becoming king. Now compare that with July 2026. The Netflix deal is gone. On March 6th, 2026, the ANL case was lost. All 97 allegations were dismissed. The cost hearing is only 13 days away, with potential personal financial liability that may have no upper limit. The Sussex lifestyle is estimated to cost around $45 million each year. According to Tom Bower's betrayal, they require roughly $3 million annually. That means the title is no longer simply a future concern. It's now the last major commercial asset that doesn't depend on securing another deal, launching another product, or building another platform to preserve its value. Tom Bower made this point in Betrayal, published March 26, 2026. A title functions as collateral. A title is a brand asset. Take away the title and you take away the asset. Those are the stakes. That's why this matters today. And that's why what the legal record actually says about Meghan's ability, or inability, to prevent a title removal is the most important part of the story that almost no one has properly explained.
The title, we've seen with Andrew, you can remove the title. It can be done. This idea before was, well, you can't do it. Well, actually, you can. We literally just did it. And Andrew's not been convicted. Andrew's not been convicted of any crime, right? But he's lost everything, and he fends for himself now. Why don't we just do that with the
Revelation number 1. Meghan doesn't actually hold the title she's reportedly preparing to fight for. Let's begin with the legal foundation, because this is where the entire narrative of Meghan will sue starts to fall apart before it even gets off the ground. Prince Harry holds 4 separate royal distinctions, and each one exists under a different legal framework. First, HRH. That's a style, not a title. It's granted through letters patent and can be revoked by the very same legal instrument. Second, Prince, a birthright title. It's permanent, and there is no legal mechanism to remove it. Third, Duke of Sussex, a hereditary peerage created when Harry married in May 2018, together with the subsidiary titles Earl of Dumbarton and Baron Kilkeel. Fourth, his knighthood. Now compare that with what Meghan actually holds. Looking directly at the history of royal women and the relevant principles of UK peerage law, the position is straightforward. She does not possess a title in her own legal right. If any titles were ever removed, they would have to be removed from Prince Harry, not from Meghan. As explained in the legal analysis surrounding the unsuccessful removal of titles, Bill 2022, Meghan Markle's title of Duchess of Sussex is a courtesy title that exists entirely because of her husband's rank. She holds no peerage independently. That means she cannot bring legal action to defend the title of Duchess, because legally it isn't her title to defend. It exists only for as long as Harry continues to hold the dukedom.
William now has got even more ammunition to say to his father, enough's enough. Let us get rid of this family. Let us even strip them of their titles, just in the same way.
Remove the dukedom and the Duchess title disappears automatically. No separate legal action is needed. No legal standing. End of story. So if Meghan can't sue over a title she doesn't legally own, could she instead challenge the HRH styling she continues to use? That's where the second legal barrier comes into view, and it's even more definitive than the first. Revelation number 2, the 4 words that effectively end the lawsuit. The source is Middle Templar magazine, published by Middle Temple, one of the 4 Inns of Court. The article was written by barristers who practice before the UK courts and examine the legal positions surrounding the Sussex titles. One sentence stands out. It is clear that it could be withdrawn by the king, a decision that would not be amenable to judicial review. Not amenable to judicial review. In plain English, that means if a decision isn't amenable to judicial review, there is no court that can entertain a legal challenge against it. The courthouse doors remain closed, not because the argument lacks merit, but because the legal mechanism to bring the case simply doesn't exist. The removal of HRH is carried out through the royal prerogative using letters patent, and the barrister's analysis is unequivocal. Withdrawing HRH from Harry and Meghan is not amenable to judicial review. At this point, you might be wondering whether another legal pathway exists. Maybe there's a different route that could still be used. Here's what the UK Ministry of Justice confirmed in response to a Freedom of Information request. The King, as head of state, enjoys sovereign immunity from both civil and criminal proceedings. That's a long-established rule of customary law, not something created by statute. So when William eventually becomes king and issues letters patent removing Harry's HRH status, the legal instrument carrying out that decision is not amenable to judicial review, and the individual issuing it is protected by sovereign immunity from civil claims. No legal vehicle, no legal target. That's the second wall. But before we reach the third, it's worth looking at what actually happened with Prince Andrew, because much of the reporting on his title changes overlooked one crucial detail, and that detail completely changes how Meghan's own legal position should be understood.
Is Meghan to blame? Is she the instigator? Is she the bad influence?
Oh, absolutely. I mean, Meghan is a source of evil. Many years ago, and it didn't make me popular with some, because she only thinks of herself. She is only focused on self-promotion, profits for her, doesn't care who gets damaged, and has behaved disgracefully, and has never made amends. And that is a problem, and has used Harry and abused the royal family. And I think that that is really where, in that whole phrase, she's brainwashed Harry, she's now going to get it back.
Revelation number 3, what really happened to Andrew and what didn't. Between October 30th and November 5th, 2025, Andrew Mountbatten Windsor saw key royal designations removed in just 4 days. But there's one important detail that much of the reporting overlooked. His HRH and Prince styling were withdrawn. His Dukedom of York was not. The House of Commons Library Research Briefing CBP-10370, updated in July 2026, sets out the legal position clearly. According to Halsbury's Laws of England, no peer can be deprived of a peerage except by, or under the authority of, an Act of Parliament. The government accepts that legal interpretation. So Andrew's dukedom remains legally intact. He lost the role. He lost the HRH style. He lost the prince styling. But the peerage itself, Duke of York, still exists in law. Now apply that same framework to Meghan's situation. If William removes Harry's HRH through letters patent, the process could happen within days. Because that decision is not amenable to judicial review, Meghan would immediately lose the HRH styling attached to her title. No lawsuit could prevent it. Suppose her legal team instead tried to protect the dukedom itself. The government's own legal position is that removing a hereditary peerage requires an act of parliament. That's exactly what the Removal of Titles Bill 2022 attempted to establish. The bill failed. It never even reached the committee stage. But here's the twist almost no one reported. The barrister writing in Middle Templar magazine considered what would happen if the dukedom were actually removed. This was the conclusion. If the dukedom is removed, Meghan and Harry will still be known as their Royal Highnesses, Prince and Princess Henry of Wales, which of course she wouldn't like at all. Think about that for a moment. Princess Henry of Wales? She would still hold a royal title because Harry remains a prince by birth, a status that cannot be removed under the current legal framework. There is no mechanism for doing so. And under long-standing convention, the wife of a prince is also a princess, not Princess Meghan, Princess Henry. So the very outcome she's reportedly prepared to spend legal fees trying to prevent would still leave her with a royal title, just not the one her public brand has been built around. If you think those 3 legal barriers tell the whole story, wait until you see what Tom Bower documented about the commercial value of that title today, because that calculation connects directly to the costs, hearing taking place in just 13 days. We'll get there in about 5 minutes. But first, let's revisit the Oprah interview, the specific moment that makes the panicked and defiant reporting one of the biggest contradictions in this entire story. Revelation number 4, the Oprah statement versus the reported legal preparation. March 7th, 2021, the Oprah Winfrey interview. The topic of titles came up, and Meghan's exact words were, "For us, titles were not something we were worried about." Now, jump ahead to November 2025. According to a Radar Online source, Meghan was really anxious, panicked, and defiant. The report claimed that titles still mattered enormously because so much of the Sussex's influence depended on being the Duke and Duchess of Sussex. Without those titles, the entire dynamic would change. The report even claimed she was prepared to fight the issue in court. So compare the two positions. Not worried in 2021, prepared to litigate in 2025. That's a remarkable shift. Now read the Oprah interview one more time. During that same conversation, Meghan described the institution as confusing and filled with rules she didn't fully understand. She also said she hadn't known what a working royal actually was before marrying into the family. Yet she was apparently confident enough to say publicly that titles simply weren't something she thought about. Someone who reportedly didn't even understand what being a working royal meant nevertheless expressed certainty about the importance, or lack of importance, of her courtesy title. 4 years later, according to the reporting, she's consulting lawyers over the very legal significance she previously dismissed. Some people will say that's simply because circumstances changed. Prince Andrew's situation changed everything. That's a fair argument. But one thing never changed: the law. The removal of HRH was not amenable to judicial review in 2021. It wasn't in 2025. And it isn't today. Sovereign immunity applied to the future monarch then, and it still applies now. The legal framework stayed exactly the same. What changed was the commercial reality, and that's where the third wall comes into focus. Because the title Meghan reportedly cannot afford to lose is the same title Tom Bower describes as the final major commercial asset still standing. As Bower put it, Meghan is someone driven by a desire for fame, financial security, and status. From that perspective, reconnecting with the royal family would restore the credibility she once enjoyed. Revelation number 5, the last asset standing. Now, let's bring the commercial picture together. In Betrayal, published on March 26, 2026, Tom Bower writes that the Sussexes need roughly $3 million every year simply to keep financial pressure at bay. At the same time, revenue streams have weakened across the board. Netflix, Spotify, Jam Retailing. One by one, the income sources are drying up. That leaves the title itself. A title is collateral. A title is a brand asset. Remove the title, and the asset disappears with it. Interestingly, the November 2025 Radar Online report arrives at essentially the same conclusion from a different direction. The titles still matter enormously. Part 5. According to that report, a huge share of Meghan and Harry's influence across the media, their business ventures, and even their charitable work comes from their status as the Duke and Duchess of Sussex. Take those titles away, and the entire equation changes. Now compare that with everything that's happened since November 2025. The Netflix arrangement is gone. On March 6, 2026, the ANL case was lost. As Ever has yet to secure a confirmed replacement commercial partnership. The cost hearing is now just 13 days away. The Sussex lifestyle is estimated to cost around $45 million every year. That leaves the title as the final piece of the commercial framework that continues to hold value without depending on a new contract, a new product launch, or another platform. And according to the legal position we've just examined, there are 3 separate barriers that mean the lawyers reportedly being consulted cannot ultimately protect it. Wall 1, Meghan holds no title in her own legal right, leaving her without legal standing. Wall 2, any decision to remove the HRH styling is not amenable to judicial review, meaning no court can hear the challenge. Wall 3, the king enjoys sovereign immunity from civil proceedings, leaving no legal defendant to sue. Tom Bower describes a commercial operation already running on fumes, and at its center sits the last major asset still carrying value. Yet that asset is surrounded by 3 legal walls, each one shielding the authority making the decision, not the individual affected by it.
The king and the monarchy has been hugely damaged by this case and by Harry's conduct. I think the judge who gave him a very sharp punch on the nose, followed by the king giving him a slap in the face by not having him at Buckingham Palace, because he realized that Harry actually, throughout the last 5 years, whether it's an accusation or all the stuff in his autobiography about the royal family and Kate and Camilla and all that, of course it's been hugely damaging, and the popularity of the royal family has fallen because of Meghan and Harry's antics. I think the king right now, his best bet would be to distance himself completely, make it clear to Harry that the Sussexes are not welcome for a very...
The collateral damage. May 19th, 2018. Prince Harry is created Duke of Sussex, and Meghan becomes Duchess of Sussex through marriage. It's a derivative courtesy title. She acquires no peerage in her own legal right from that point forward. March 7th, 2021. During the Oprah interview, Meghan states, "For us, titles were not something we were worried about." June 20th, 2022. Labour MP Rachel Maskell introduces the Removal of Titles Bill, an attempt to establish a legal process for stripping hereditary peerages. The proposal fails and never reaches committee stage. October 30th to November 5th, 2025. Prince Andrew loses his HRH and prince styling within 4 days. His Dukedom of York, however, remains legally intact. November 2025. Radar Online reports that Meghan is panicked and defiant, allegedly consulting legal experts. No lawyer is identified, and no court papers are filed. March 6, 2026. The Netflix equity arrangement connected with As Ever comes to an end. March 26, 2026, to Tom Bower's Betrayal is published, describing an estimated annual requirement of $3 million and characterizing the royal title as commercial collateral. July 7, 2026. the ANL judgment is handed down. All 97 allegations are dismissed. Harry labels the decision a whitewash. July 29th to 30th, 2026. The annual cost hearing approaches with a reported £22.66 million insurance gap still to be determined and potential personal liability that may be uncapped. Now, break the legal position into 3 simple categories. Category 1. The 3 legal barriers. The removal of HRH through letters patent is, according to the Middle Templar barristers' analysis, not amenable to judicial review. That means no court can hear a challenge. The sovereign is protected by sovereign immunity from civil proceedings, a position confirmed by the Ministry of Justice through a Freedom of Information response. That means there is no legal defendant to sue. And the title Meghan seeks to retain is not legally hers in its own right. It exists only because Harry holds the dukedom, a principle established under UK peerage law. That means no legal standing, 3 legal barriers, 1 reported lawsuit, no legal route. Category 2. The peerage distinction. The dukedom itself, the underlying hereditary peerage, cannot simply be removed by royal decision. According to the government's confirmed legal position, doing so would require an Act of Parliament. The Removal of Titles Bill 2022 attempted to create that mechanism. It failed. No replacement legislation is currently before Parliament. But here's the overlooked consequence. Even if Parliament did remove the dukedom, Meghan would not simply become Meghan Markle. She would instead become Princess Henry of Wales, because Harry's title as prince is a birthright that remains permanent under the present legal framework. Middle Templar points directly to that conclusion. So, the outcome she is reportedly trying to avoid is not actually the legal outcome that title removal would produce. Category 3. The commercial reality. According to Tom Bower, the title has become the last major commercial asset still carrying measurable value. The reported annual financial requirement stands at around $3 million. Revenue streams have weakened. Commercial opportunities have narrowed. The title functions as collateral, yet the reported legal action cannot preserve that asset because of the 3 legal barriers already discussed. And with the ANL costs hearing only 13 days away, the financial pressure increases at precisely the moment that legal protection appears least available. Now consider the timeline. In March 2021, Meghan publicly told Oprah that titles were not something we were worried about. By November 2025, reports described her as consulting legal advisors specifically to retain those same titles, arguing they represented the final pillar supporting the Sussex commercial operation. Yet the reported legal strategy faces 3 established obstacles. No standing to defend a title she does not legally hold. No court able to review the instrument removing HRH. And no legal defendant because the future monarch benefits from sovereign immunity in civil proceedings. Then comes the consequence that received almost no attention. Even if Parliament eventually removed the dukedom, Meghan would still hold a royal designation as Princess Henry of Wales, just not the title around which her public identity has been built. Tom Bower argued in March 2026 that the title had become the last significant commercial asset. The legal record suggests that asset cannot be defended through the courts. And with the ANL costs hearing approaching in just 13 days, the financial stakes become even higher. So here's the question. A specific answer, not speculation. In 2021, Meghan said titles were not something we were worried about. 4 years later, reports claim she was consulting lawyers specifically to keep those titles. If the legal framework governing title removal remained unchanged between 2021 and 2025, no judicial review, sovereign immunity, and no legal standing, what specifically changed during that period that made those titles worth defending? Tell me what you found, not what you assume, what you found.